Hi, Ryan.
Andrew.
So it's Thursday, April 24th, in the morning, and we wanted to jump on and talk to folks about what uh, Ryan has called a sleeper case, meaning it's a federal case that has gotten very little attention, and we wanted to try and amplify what is going on in that case. Uh, and, kudos obviously to the plaintiffs in that case. But Ryan, thank you so much for flagging that. In part, I'm just going to do a quick shout out to Just Security, which has a litigation tracker. So that's how things get on the Just Security radar screen. But let's jump right into this. This is a federal case in Massachusetts. The name of the case, it's pretty a catchy name. It's D.V.D. is the first plaintiff. I'll explain in a moment why it's called D.V.D. And then there are a series of defendants, which are become important when we talk about this case, but starting with the Department of Homeland Security. Just very quickly, it's called D.V.D. because even though there are four named plaintiffs, they have been given permission to go by initials and not their full names for a whole series of reasons, including, sadly, the sort of opprobrium, but also threats of violence that can happen to them. And so, for privacy reasons, the court can and frequently, in cases like this, will have initials. So, for shorthand, we'll just call it the D.V.D. case. And just before I turn it over to the key issue that is why we're talking about this, which has to do with contempt, it's important to understand the nature of the claim. It is an immigration case, so it's similar to the Judge Boasberg case, to the Texas case, that both of which have gotten a lot of attention, to the Garcia case, but it is a different type of claim in this sense. These are plaintiffs who they admit that they have been given some process and there have been removal orders, but, and this is critical, what they're saying, the contention in their federal complaint is they're being removed to third-party countries with no notice. In other words, they're not just being told, oh, you're going to go back to the country you came from, but suddenly some third-party country, so in other words, some unknown country that they've never been able to contest their return to. In other words, it's not even returned to, I would say it's being sent to. So, for instance, if you have a fear and it's a validated fear from the court, if you get sent to country X, these kinds of things can happen to you because of your ethnicity or religion, or some other affiliation. You're entitled to make that claim, and then you can be sent to essentially a safe country, not to a country where you have fear of persecution. And so the plaintiffs here say, with no notice whatsoever, sound familiar, and no judicial hearing to contest where they're going, the Department of Homeland Security is just willy-nilly sending them off to countries without ever giving them that due process. So that's the nature of the claim here. But importantly, the judge overseeing the case issued a temporary restraining order. And that's, Ryan, where I'm going to turn it to you, because exactly what the judge ordered becomes very relevant, because, just spoiler alert, we're going to talk about what appears by all accounts to be a violation of a court order. Obviously, we have talked about that in connection with the Judge Boasberg case, where he has found probable cause for a violation of his order. We know in the Abrego Garcia case that the judge has also looking into a violation of her order. We have similar issues in Texas. We know in different cases, there are other judges looking at similar issues, which is remarkable. The federal government violating court orders. But this is one where we really want to make sure everyone has this one on their radar screen, because Ryan, what you're going to talk to us about is the temporary restraining order, what its language is, and then what we know the government has done even after that temporary restraining order. So what's the nature of the temporary restraining order? What did the judge do to sort of put a hold on what's happening so that he could hear more evidence about what's going on?
Great. So the case was brought on March 23rd. The named defendants in the case include the Department of Homeland Security and the Department of Justice. And then the important date for everybody to keep in mind is March 28th. On March 28th, Judge Brian Murphy of the District of Massachusetts issued the TRO. And the temporary restraining order, as Andrew, you just said, was to freeze everything in place. And he says specifically that essentially, he says essentially, and then I'll read the exact words. He says essentially, the Department of the named defendants and anybody working with them shall not remove any individual from the country, the United States, to a third country, in other words, a country of which they're not a national, unless and until they do the two things that the plaintiffs have asked for, unless and until they've given them notice that they're actually moving, that they being the government gives the individual notice that they're being moved to a third country, and gives them the opportunity to then contest the movement to that country under the grounds that they fear being tortured there. So the temporary restraining order says specifically, and here's now, I'm just going to read it out.
Yep.
Defendants and all of their, which defendants meaning DHS, DOJ, and all of their officers, agents, servants, employees, attorneys, successors, assigns, and persons acting in concert or participation with them are hereby enjoined and restrained from removing any individual subject to final order of removal from the United States to a third country, i.e. a country other than the country designated for removal immigration proceedings, all caps, unless, and all caps, until defendants provide that individual and their respective immigration counsel, if any, with written notice of the third country to where they may be removed, and all caps, until defendants provide a meaningful opportunity for that individual to submit an application for Convention Against Torture Protection to the Immigration Court. Full stop. So we're done. And so that's the temporary restraining order. Do you want us to jump to?
So I just want to make sure people get this, which is that the defendants here are enjoined, and the defendants are two entities, which is the Department of Homeland Security and actually it's the Department of Homeland Security as one entity, Christine Nome as the Secretary of the Department of Homeland Security, Pamela Bondi, the U.S. Attorney General in her official capacity, and one other person who is the superintendent of Plymouth County Correctional Facility, because, as the complaint says, one of the plaintiffs was currently housed in that facility. So it's sort of that one entity and then a series of individuals, and they are specifically enjoined by the temporary restraining order. And this temporary restraining order covers a whole series of people who work for the Department of Homeland Security, because the temporary restraining order, let me just read the language, with respect to the Department of Homeland Security, includes the officers, agents, servants, employees, attorneys, successors, and assigns of anybody at the Department of Homeland Security, meaning essentially trying to cover everybody who's there. And then I think also importantly, anybody who's working with the defendants. In other words, this is in criminal law, it's a very common thing to talk about people who are conspirators or aiding and abetting. some principle. And so the language here is sort of tracking that idea, which is the defendants can't do this, and anyone working with them, in concert with them. And the language is persons acting in concert or participation with them are also enjoined. And so that is what the judge put in place. And then, Ryan, there is a filing by the government saying what they did. And what does that filing say? And then we'll turn to sort of um, what questions we have based on that filing and what it seems to suggest with respect to a violation of this temporary restraining order.
Sure. So the filing is submitted last night. Let me I guess back this up one bit. The temporary restraining order is issued on March 28th. On March 31st, Secretary Rubio boasts that the United States has just removed 17 people to El Salvador CECOT prison. And the attorneys are immediately alarmed that sounds like a violation.
And that prison, that is the prison where the planes took off from in the Judge Boasberg case, where there's now contempt proceedings in connection with whether the government how they responded to Judge Boasberg's order that nobody be removed and planes are going there to be returned. It is also the location in connection with the Abrego Garcia case, because Mr. Abrego Garcia is there now, in spite of the fact that there are numerous orders that have been violated and the government agreeing that they made a mistake. So that is the prison. It's the El Salvador prison. And these people have appear to have been taken there because as you said, the Secretary of State boasted about it.
Yeah, he boasted about it, and his boast is specific enough to say that the 17 include Venezuelan nationals who are accused by the government of being members of the Venezuelan gang. So that's Venezuelan nationals being taken to the El Salvador prison on March 31st. And that so the plaintiffs are alarmed by that. There's a news stories about it. They're quoted in the news, some of the lawyers. Like, this seems to be a violation of the temporary restraining order, which was just 3 days before, March 28th. So lo and behold, this is now litigated, and the question is, what has the government done? And then last night, which is Wednesday night of this week, right around 7:30 p.m. Eastern Coast time, the government submits a filing, and the filing has two parts to it. One is basically the government brief, and then there's this ICE official affidavit. And what the government
and ICE is the Immigration and Customs Enforcement Agency.
Right. So what the government's basically saying is that there were indeed 4 individuals who were removed from the United States to El Salvador, who are Venezuelan nationals. And their argument appears to be, yes, they were moved, but they were moved by the Department of Defense. And DHS had nothing to do with that. And so DHS is one of the named defendants. And so DHS did not violate the order because it wasn't DHS's plane. It was the Department of Defense's military plane that took them to El Salvador.
So what we have is a filing that says, with respect to people who the plaintiffs and the sort of putative plaintiffs who are covered by the TRO, the government is saying, we admit that we have moved them, but it's a different part of the government, and the claim is that it's a part of the government that's not covered by the temporary restraining order, because nobody who is a defendant in this case before the federal judge actually was flying the plane.
Right.
And I think in the in the filing, they say nobody from the Department of Homeland Security was on the plane.
Yes.
I think that's one of the things they say, and they say that the Department of Homeland Security didn't direct the Department of Defense to remove them.
Yeah,
The
in fact,
problem with that, yeah.
and
Do you want to
I'll
say
just
maybe
I'll
read
just
what?
read.
Yeah,
Yeah, I'll read one verbatim. Blank's name, because it's redacted, an admitted TDA gang member, that's the Venezuelan gang, was removed to El Salvador on March 31st, 2025, by the Department of Defense on a flight where no DHS personnel on board. I'm sorry, there's a little bit of a sick there because it should be where there were no. DHS did not direct the Department of Defense to remove person's name. The Department of Defense is not a defendant in this action, end quote. And they say that repeatedly for each of the individuals.
right. So one of the things before we get to what appears to be a clear violation of the temporary restraining order is the filing takes a lot of liberties about denigrating these people and their backgrounds. All of that is irrelevant to the due process issue. Bad people get due process. Good people get due process. Due process is not a popularity contest. Under the government's theory, where you denigrate people, why even have a trial in a normal criminal case if they're charged with something bad? It just doesn't work that way. That is why Judge Wilkinson, a conservative jurist in the Fourth Circuit, was so sort of appalled in his decision that we have talked about. So that's sort of a notable filing because it's so anathema to what our government and the Department of Justice and the Department of Homeland Security should be saying. I mean, it's fine to do some of that, but to make it clear as that's sort of irrelevant to the due process issue. The In other words, if you're going to use it, you have to tie it to something relevant legally. And so the problem is sort of multifaceted because one, people who are listening to this can go back to and why we're very focused on the language of the temporary restraining order, because there are two ways in which there could be violations here, at least. One, with respect to the Department of Defense, they're actually covered by this if they are acting in any way in concert or complicit with the defendants who are covered. That is the exact language that we were focusing on. So if they're aware of this court order, which obviously it's hard to believe that they wouldn't be. I'm not saying every single person in the Department of Defense, but the people who are doing this are being given this task, presumably precisely to get around this order. So they're aware of the issue as to the court order. And if they weren't made aware of it, it's even more evidence of the flagrant violation by the defendants because they have custody of these people at the time that the temporary restraining order goes into effect. So the Department of Homeland Security and the superintendent of Plymouth County Correctional Facility, if they have custody of these people, they were given direction about what they could do and could not do. And one of them is not turning these people over to be deported. And so they would have to make a claim that when they were turning them over to the Department of Defense, they had no idea that the Department of Defense wouldn't comply with this order. Because if they did know that, I don't see how they make an argument that they are in compliance. And if I'm the judge, I'm having a hearing immediately, and I'm asking them about those two issues, both the named defendants and how they when they had custody and why they turned these people over to the Department of Defense. And then second, with the people who actually removed them, the Department of Defense people, who did it, under whose orders, and what they knew, all of those people, what they knew about this order. And just to be clear, in any normal case, if we weren't seeing this sort of so many repeated issues coming up in so many federal cases, this would be just a huge deal. And having been in the government, and Ryan, I know you have too, I mean, the idea that we're talking about this in connection with the government, that the government is violating a court order is huge. And so that is the reason that we are having this conversation right now, because this, to me, I don't know if you agree, Ryan, but to all accounts, this looks like it really should be in hot water trying to explain their way out of this. And just to be clear, this means that not only the plaintiffs have not been given due process, but that the government would have violated not just their due process rights, but also violated the court order telling them not to do this.
Yes. And let me illustrate the alarming nature of it one way, and then just say a couple specific points about who the named defendants are. One, when the decision dropped, I sent a text message to a colleague friend of mine who closely tracks these cases. And my text message basically said, "Holy shit, DVD," at 7:29 p.m. To which they replied within 4 minutes later, after me sending them the government filing, "Holy shit." It's just incredible, just from the face of it, when you immediately see, oh, this idea that it doesn't apply because DOD was operating the flight. So I think in some ways we've stated the exact propositions by the DOJ in its filing, but it's just extraordinary what they're saying in that moment. And then just to drill down a tiny bit on the named defendants, one is another named defendant is the Department of Justice, and there's something obviously conspicuously absent from the statement that I read out, which is, okay, so maybe DHS officials weren't on board the planes, and it wasn't whatever they might mean by the words directed by DHS. What about the Department of Justice? They
Is
didn't.
it just technically, Ryan, I think it's Pam Bondi who is the named defendant, not the Department of Justice itself. Not that should, I mean, obviously she has control over the Department of Justice because she's the Attorney General, but just for technical sake, I think I'm right.
Yep, you're right. You're right.
Okay, it's not that relevant. I just wanted to make sure our listeners had that.
Yeah, that's great. And then this, so that's one, which is, it doesn't excuse them whatsoever if they didn't have like Department of Justice officials on board the plane. It's just that their hands must be all over this. I assume that Pam Bondi was well aware and authorizing the movements. So that's one piece of it. Second is the superintendent of Plymouth County Correctional Facility. There, I just want to leave a question mark in the sense that it's not so clear to me from the government filing if any of these four were necessarily in that person's facility. Because the temporary restraining order applied to all individuals that could have come from anywhere in the country and then moved onto these flights and to Guantanamo and onto these flights. So that would be just an open question otherwise.
And the final piece is the irrevocable nature of this from the government's perspective. Everyone will remember and knows that the reason that Mr. Abrego Garcia is still in El Salvador is because the government's position is that they have no ability to have him returned, or that the courts have no role in requiring them to do anything to have these people removed from that prison and brought back. And so not only is there a due process violation found because the court is saying these people are entitled to that hearing, not only does there appear to be a clear violation of the temporary restraining order, But now that these people have been removed to that prison, they are now essentially in a dungeon for life. And with the government's view that once those planes took off, that's it, they're done. So the harm to them is extraordinary if the court finds all of that to be the case. And I think maybe a final point is I think that's the reason that you are hearing from so many people on the right and the left talking about what is going on. And it is not just what I say when I'm on air. It's not just the MSNBC crowd. This isn't sort of, oh, people saying Chicken Little, a hair, the sky's falling, hair on fire, whatever expression you want to use. The Wall Street Journal editorial page, Joe Rogan, other sort of serious conservative thinkers and jurists talking about this, because this is not what they signed up for. You might have policy disagreements, but this really appears to be yet another serious violation of law by this administration.
Yeah. And I just want to put out there one other idea, which is I think that we've explained the main problem with what's happened here in the government's filing last night, which in some sense is an admission. And I just want to at least put out there for folks that if we were to go to a backup argument, if the government somehow were to say some aspect of which they, because I think they might try to claim something like, oh, because DHS didn't direct DOD, then it wasn't acting in concert or participation. A ludicrous position, I think, would just fail. But in addition to that is one way of putting it, what the affidavit from the ICE official makes very clear is that the individuals, these 4 individuals, were in ICE custody after the TRO. It's not as though they were in DOD custody on March 28th and then DOD flew them out of the country. It's that on March 28th, they are in ICE custody, and it is after March 28th that ICE gives them to DOD, and then they're flown out of the country. That's, to me, another remarkable aspect of it, because you get that if you read the affidavit. You actually don't get that if you read the government's brief. If you read the government's brief, you're just thinking, okay, well, who has custody at what time and at what point? And it's revealed later in the attached affidavit.
And ICE, just so people know, ICE is a part of the Department of Homeland Security, and the Department of Homeland Security is clearly covered by the temporary restraining order. And so this is why, Ryan, thank you so much for flagging this when it all came down last night. And we wanted everyone to keep this on their radar screen. And this is definitely one, stay tuned, because it's hard to imagine that the plaintiffs aren't going to ask for sort of contempt sanctions, and that could include findings of civil contempt. It can include findings of criminal contempt, all the kinds of things that we're seeing, again, I won't say around the country, because not yet, but certainly it is now in a variety of courtrooms in the country. But this seems to be yet another front and center. So stay tuned.
Thank you.
Take care.